rise. Minnesota Workers' Compensation Court of Appeals session is resumed. The Honorable Thomas Christensen presiding.
Good morning. Please be seated. Welcome to the second oral argument before the Workers' Compensation Court of Appeals. Today's date is December 18th, 2023. Again, I'd remind counsel, I think you've been here before, that the argument today is being live streamed and recorded, and we ask that you speak loudly and clearly during your respective arguments. The second case today is captioned James Jurgensen versus Dave Perkins Contracting, Inc. and TBG Claims Services, our file number WC236534. We have a three-judge panel this morning. On my right is Judge Carlson. To my left is Judge Sundquist, and I'm Judge Christensen. To remind counsel, you have 15 minutes to present your arguments this morning. We ask that you keep track of your time and reserve any time that you feel necessary. Please be aware that questions from the panel can be expected any time after you begin. In the past, we've given you 2 or 3 minutes of free time to argue before asking questions, and we've done away with that process. I know we have very experienced counsel this morning. Would ask that when stepping to the podium to please identify yourselves and your respective parties. I believe, Mr. Borkin, this is you're up first.
May it please the court, counsel, good morning. I was joking with Mr. Simpson earlier this morning that he should be at the same table as me because we're here on a dispute not raised by my client, the employee, not raised by the employer and insurer, but instead the dispute that brings us today was initiated by the compensation judge. And that fact alone should be reason enough to find that the judge's findings are not supported by substantial evidence. We're here today because the compensation judge thought it was necessary to conduct an attorney fee hearing on a stipulation for settlement when all parties agreed that the fee being sought was reasonable. The point of the Irwin factors and the point of an Irwin analysis is to determine whether an excess fee is reasonable. That's completely unnecessary in the present case because all parties agreed that the fee was reasonable. We stipulated to that fact. But the judge held a hearing anyway. And I ask you, what is the point of a stipulation if the judge chooses to ignore it?
Mr. Borkin, so my question for you is, how is this case any different from Mack versus City of Minneapolis, which was a Minnesota Supreme Court case in 1983?
Well, this case is a stipulation for settlement. That case was about that case was disputed. And that's a case that went to trial. This case didn't go to trial. This case didn't go to hearing. We have a stipulation for settlement. So I think there's a big difference between attorney's fees that are disputed and going through the Irwin factor analysis when the employer and insurer disagree with what the fee is that's being sought, and a case where we've stipulated and agreed to a stipulation for settlement for $150,000 and there's no dispute as to what the attorney fee is that's being sought. There shouldn't be an attorney fee hearing when we agree on what the attorney's fee should be. When I put in my retainer agreement that I will seek excess fees. When we put in the stipulation for settlement that we're going to seek excess fees and the client agrees to it. Client agreed to the retainer agreement. We put in an excess fee exhibit explaining my entitlement to the excess fees. I drafted an attorney fee memo going through the Irwin factors explaining the excess fees. And there was no evidence submitted at the hearing in contradiction to whether or not I was entitled to the excess fees. So all of those facts are different than Mack versus City of Minneapolis, where there was a dispute over what the fee should be. And that wasn't the only thing we stipulated to in the stipulation for settlement. We stipulated to the average weekly wage in the stipulation for settlement. There wasn't a hearing held on what the average weekly wage should be because we stipulated to it. There's no need for a hearing on the average weekly wage. And that has a bigger impact on what the employee could possibly get over the course of his claim than what any excess fee amount could be.
Mr. Barkin, is your argument that the compensation judge did not have the jurisdiction or authority to decide to change the fees agreed upon? Or is that your settlement or your agreed upon fees should take precedent over a judicial determination of fees?
I am not arguing that a judge doesn't have discretion to review a stipulation for settlement. What I'm arguing is that there's no need for an attorney fee hearing when there's a stipulation for settlement submitted, when all parties agree on what the fee should be. So I acknowledge that the compensation judge retains jurisdiction over the stipulation for settlement, but the compensation judge's role in reviewing a stipulation for settlement, especially when both parties are represented by counsel, is to determine if this settlement is fair and in conformity with the statute. And there's less of a review that needs to take place when both parties are represented by counsel. It should be, the factors in approving the stipulation for settlement should be, are there any parties that aren't being left out in this case? Was there an intervener that wasn't put on notice or excluded from the stip? Or is this fair and clear? Can I tell what benefits are being closed out and what benefits are being agreed to? That's the compensation judge's role in reviewing a stipulation for settlement.
But isn't a compensation judge role similar to the policy outlined in the Mack versus City of Minneapolis case, in which the court said that the policy behind the statute for attorney fees is to protect employees or claimants from excessive legal fees, which may deplete funds badly needed by the employee and or dependents. And the second part is to ensure that the attorneys represented the employees are reasonably compensated. So in this case, although you did agree with, well, all parties agreed that these fees are reasonable, didn't the judge have that authority to go ahead and try to protect your client from what that judge deemed to be excessive legal fees?
No. My client hired me to look out for his best interest. He did not hire the compensation judge to do that.
Mr. Borgen, on that same note, and again, looking at Mac, well, first of all, let me back up. Under 176.521, you've already talked about what the judge is required to do is basically make sure all parties are involved. Isn't it the compensation judge's job also to make sure that the stipulation is in conformity with the Workers' Compensation Act?
Yes.
And that would also be 176.081 and by extension of that, what is in your retainer agreement?
Correct.
And so if your retainer agreement is not in conformity with the Workers' Compensation Act, that might also give rise to discuss your fees and have a hearing on it.
There was no allegation by any party that my retainer is not in conformity with the act.
Do you feel that your retainer agreement is in conformity with the act?
I do. I think it's important to notify a client if you're going to make a claim for excess fees, and I think it's important to do that at the outset of representation. And so if I intended to make an excess fee claim on any recovery above $126,000, I think it's important for the client to know that as soon as possible.
And specifically, your retainer agreement provides that your office will attempt or make a petition for an excess fee of 20% of anything over $130,000, regardless of the time. Just as long as the amount is over $130,000, your office will then try to collect the additional 20%, correct? And Mr. Borkin, and I've seen the retainer that was marked as an exhibit, and I did read the provision about your office seeking the additional fee, but what I didn't see is what is required under subdivision 9, and I'll just read this. The employee shall take notice that the employee is under no legal or moral obligations to pay any fee for legal services in excess of the foregoing maximum fee. And that's required by the statute to be in your retainer agreement, but I didn't see it in there. So you agree that your retainer agreement is not actually in specific conformity with the statute?
I don't agree that my retainer agreement is not in conformity with the statute. I mean, we put in excess fee language in the stipulation. We don't make a claim for excess fees without including that specific language in the statute, saying that they have a right to object to that fee.
Well, and your retainer agreement says what it says, but let me get back to your point. You said that your client retained you, not the compensation judge, to represent them. And again, I'm going to paraphrase Mac, whereas Mac says when it comes to a settlement, certainly you and your client are on the same page. You're working towards the same goal. But when it comes to negotiating an attorney fee, you're not. Your client is not represented in negotiating a fee with you. And certainly defense counsel they don't really have a say in it either, because and I hate to put words in your mouth, Mr. Simpson, but they don't really care where the money goes. So really your client has no representation then if it's not going to be the judge making sure that your retainer and that the fee is in conformity with the Workers' Compensation Act, because your client then is not represented for negotiating your fee. Would you agree with that?
Not necessarily. I mean, I have an ethical duty to do what's best for my client. And so the client's interest is represented by me. I still have an ethical duty to put my client's interest ahead of my own. And I do that in every case. And that is why we have that additional language in a stipulation for settlement, acknowledging that there's an excess fee being claimed, that my client can object to the excess fee claim, and a hearing can be held if he does object. But he didn't. You have to take my client at his word. We had an attorney fee hearing. My client was there. He's here today.
And
we're not
sure,
pulling the wool over his eyes.
Mr. Borkin, I don't think anyone is arguing with you that your client agreed to this fee. And I think that everyone agreed that you did a really nice job for your client. The question is did Judge Surgis have the authority to limit your fee to the $26,000? So let me ask you this. Do you feel that the $26,000 was not a reasonable fee for your work on this case?
I do.
And why do you feel that it was not a reasonable fee based on the 24 hours that you had in this case?
Because we obtained an excellent result for the client. We obtained $150,000 on behalf of the client. And I'm simply asking for 20% pursuant to 176.081. The statute calls for 20% of all recoveries made on behalf of the employee. That's what I asked for. That's what I was seeking. That's a fair amount for attorney's fees on the recovery that I made. If we receive a 100% result, we should get paid 100% of the recovery. I'm asking for 20%. I don't think 20% is excessive. We have the lowest contingency for fee percentage of any area of law in Minnesota. 20% is the lowest. Personal injury gets 40%. Short-term and long-term disability get 40% plus, some of the future benefits. Employment law, 45%. Family law, hourly. The only person who's not getting paid right now is me. We take on risk. We take on tremendous risk when we represent injured workers. I lose like 12 cases a year. That's 12 weeks. I spend 40 hours on each one of those cases. That's 12 weeks I don't get paid.
So, Mr. Borkin, I think I'm understanding your argument. You're saying that the $26,000 is not fair, not because it doesn't compensate you for your time, but it's not fair because of the result and because of the risk you took on.
It's both. So the time I spent, you saw the itemized time. I spent over $9,000 worth of time. I'm asking for a $4,000 excess fee. So it both doesn't compensate me for the time because I have to justify the excess amount, not the first $26,000 because that's considered fair and reasonable.
Well, let me ask you that. What's your legal authority for stating that the Irwin factors are only applied to the $4,000 excess fee?
It's the statute, because the statute says the first $26,000 is presumed to be reasonable.
But under Irwin, don't you look at all of the money? You look at the $26,000 and see if that is reasonable before you look at the excess?
No, because the statute says it's presumed to be reasonable. So you don't look at the first $26,000. That's what a presumption is. It's not a rebuttable presumption. It's presumed to be reasonable. And so therefore, the Irwin analysis is only on the excess amount. That's why the statute says presumed.
Is there a case that says what you think 081 says?
I think that's what Irwin says. That's my position on what Irwin says, and that's what the statute says.
Mr. Borkin, I think we all agree that the Workers' Compensation Act is a creature of statute, and the 20% that you reference, that's in the statute. So the legislature has determined that the 20% up to the 130 is the maximum fee schedule. So if you want to change above the 20% to 40% or something else, isn't that something that the legislature needs to do, because we're limited here to what the statute says?
Yeah, if I were to ask for more than 20%, yes, the legislature would need to change the statute. But I didn't ask for more than 20%. I asked for 20%.
Mr. Borkin, I'm going in a completely different direction here, but let's look through the rules for attorney fees, 1415.3200. And it struck me as odd that at the last section, that would be section 8, subdivision 8, talks about cases in which an attorney fee claim is filed and there's no objection, which is basically what we have here. You know, we have an attorney fee claimed, we have no objection filed. And under that section of the rules, it says where no objection to the requested fee has been filed, the judge or court before whom the matter is pending shall issue a summary decision regarding the amount of fees owing. Do you think that is supportive of your position in this case?
Certainly do.
Yeah, I do too. I'm not sure how it fits, but it just seems like it'd be supportive. I'm just wondering, though, does it conflict with the Supreme Court's decision in Mack versus City of Minneapolis?
No, I don't. Because again, Mack was a dispute regarding the fees. And it was in dispute how much fees were owed, right? The employer and insurer disputed what the amount of the excess fee was and whether or not the employee's attorney earned that fee. And this rule says when there is no dispute, when there is a stipulation, when the parties do agree on the fee, that the fee should be approved. Because we shouldn't be using judicial resources on a matter that is not in dispute when both parties are represented by counsel. Thank you.
Any more questions, Judge
Nobody else?
Carlson? Judge Lundquist? Mr. Rorke? Mr. Simpson?
Thank you. Good morning. May it please the court, my name is Robin Simpson. I'm the attorney for Dave Perkins Contracting and the Builders Group, their insurer. And while I'm here as respondent, as Mr. Borkin indicated, we're seeking the same result that he's seeking in this case, that is award of the excess fees sought. And my perspective on this, I think, is possibly a little closer to what Judge Sundquist indicated. So we've got several arguments here. The first is that it's been found unconstitutional to have a hard cap on fees. That's very clear. It's also very clear, I think, in this case, that that's not what the judge did. She didn't bypass any of the rules or any of the requirements of the case law. She went ahead and did an analysis. The interesting thing, and Mr. Borkin didn't mention it in his oral argument, but he did in his brief, is a concept of contract law. And he cites several cases there, which is essentially in a stipulation, you have a contract, right? It sets out the rights of the parties. It sets out the parties' intent. What the case law says in that case is what the courts should do is take a look at the contract and to see if it accurately, you basically try to divine what is the party's intent and make sure that the contract is interpreted and effectuated to give the party's intent, to be consistent with that. And I think, well, it's also clear that the judge did have jurisdiction and did have the ability to review this. So that was proper. What I think her review should have done then is to look, what is this agreement and what is the intent of the parties? And is that clear? If she didn't think it was clear, a hearing is certainly possible and would be appropriate. Here, there was a hearing. Mr. Jurgensen testified at the hearing very clearly as to what his intent was and what he wanted out of the settlement and what he wanted the effect of the attorney's fee portion of it, which was that excess fees be awarded.
Mr. Simpson, sorry, I'm going to
Not at
interrupt. I will ask, as a question to what you have just said, I want to ask you the same question that I asked Mr. Borkan. Isn't the purpose of 176.521, at least in part, is to ensure that all stipulations for settlement are in conformity with the Workers' Compensation Act?
Yes.
Agree with that? And so regardless of the intent of the parties, the judge still has to make sure that the stipulation for settlement is in conformity with the Workers' Compensation Act. That's more important than the intent of the parties or retainer agreement. Would you agree with that?
It would be if there was a clear indication or if the rule cited by Judge Sundquist wasn't in place to indicate that in a stipulation context, in a situation where you have agreement to the parties, no objection, that probably the next step then is to take a look at the intent of the parties. Is it clear? The court could have taken a look and said, you know, it's not clear to me, for instance, that Mr. Jurgensen was fully informed. The language isn't clear in here to say that he would know that his intent that his attorney should get excess fees is clear by this document. But here, it's pretty clear. I mean, it's clear in the retainer, it's clear in the language of the document exactly what the fees are going to be and why. It even goes through some of the factors, the Irwin factors in the stipulation itself. And then in at least a couple different places, the employee who's a competent adult signed off and said, yes, I agree with that. So for the judge, I think that's the next step, is to see, because we are in a contractual situation, and as Judge Sundquist indicated, we're in a situation where there is no objection. That's really the next. The judge reviews it. Is there anything amiss? It seems to be pretty clear. Maybe I have a hearing to make sure. That seems pretty clear. That's probably about as far as it should go. The only other thing I would say is if the court should find that it's appropriate to go to the Irwin factors, it's our possession that they were satisfied here. We have no objection to the fee, and we agreed in the stipulation and agreed that it was reasonable and fair. So if there are no other questions, that's basically our position.
No questions.
Nothing else?
Thank you.
Thank you.
That concludes today's oral argument. We have 90 days to issue a decision, and you will receive it. Thank you.